Let's get started then. Um, Welcome to today's webinar. We're, of course, discussing AI as a tool for your businesses. The China IP SME Helpdesk has partnered up with KrEurope to present this webinar. And of course, there'll be an introduction into their network later on. Without further ado, maybe let's get started. So the China IP SME Help Desk is an initiative by the European Commission to help European SMEs, so small and medium enterprises, to protect their intellectual property when doing business in China. We have 4 regions that we refer to as China. So it's mainland China, Hong Kong, Macau, and Taiwan. And each of those regions have their specific IP landscapes. They all have their different laws in terms of IPs. So if you're interested in doing business in any of those regions, we can help you with that. And the project was launched in 2008. And since then, we've helped multiple hundreds of thousands SMEs. And we offer consulting services to businesses in the single market program, so EU and some other countries as well. And our main service that we offer is our helpline. So if you have any specific question that you need to be answered in terms of, oh, can't see my slides. Sorry, 1 second. How about now? No. Uh, hmm. Okay. Okay. Great. Is it still, I hope it's still working, but please let me know, unmute yourself, because then I would be able to hear better if you don't see it. Sorry about that. So yeah, like I was saying, our helpline is our main service that we provide. And if you have any specific question about protecting your intellectual property in the 4 regions that I mentioned earlier, you're welcome to use it. It's free, fast, and confidential. So anything you ask will not be shared with anyone else. And we always answer within 3 working days. So if you already do business in China and you have a specific problem that you need help with, or if you plan on doing business in the future in China and you are unsure about certain steps, you're welcome to write to us in the email address here, question@china-iprhelpdesk.eu. Or if you're already in China, you're welcome to also call us, or if you want to pay for the international call fee, you're also welcome to call us if you prefer that. But we also offer a wide range of other services. We have a lot of trainings that we offer, just like this one, a lot of webinars that we partner up with other organizations to bring together people that are interested in this topic and to explore certain topics or industry-specific issue that we can discuss. We also offer one-on-one consulting sessions with an IP business advisor based in Beijing. So if you already are doing business in China and you need help with your business strategy, or if, like I said, if that's something you want to do in the future and you need help with a plan to be able to do business there safely, we can offer one-on-one consulting sessions with someone that will help you do a plan tailored to your specific situation and to your specific needs. On our website, we have a lot of self-learning materials. We have a lot of resources that you can use if you have any issues, anything that you want to learn about in terms of IP in China. If you want to know how much it costs to register a patent in mainland China, you'll find it there, or really whatever you need to know. We have everything free of charge on our website. And actually, all of our services are free of charge since the project is fully funded by the European Commission. So we really are here just to support European SMEs. This is an example of some of our fact sheets. And we have basically overviews with all the information you have to know about the 4 regions I mentioned. And we also have industry-specific guides. So on the slide, you can see about technology transfer. And we have different guides for different industries. So if you work in the cosmetics industry, there's a guide for you with everything you need to know about doing business there, and so on. And actually, the China IP SME Help Desk is part of a wider range of EU-funded help desks. They are present in all these regions that you see on the screen. So if you do business or want to do business in any of these other regions, there's also help desks that can help you for those regions as well. And their websites can be found in the link below, and that website will also send you to our website. Sorry, that link will send you to our website. So if you want to stay connected, here you have our X and our LinkedIn. That's where we post the most about our updates, about what we're doing. We provide tips and any other information you may want to know about IP in China. So you're welcome to connect with us on there. We also have a YouTube channel where we post videos about IP. We post past webinars. So if you ever miss a webinar, you can always go back to our YouTube. And if you're familiar with China, you would know that they use a lot of WeChat. So you can also add us on WeChat if you want to scan the code right here. And that's it for me. I'll give the floor to Iman Wang from KrEurope. So.
Great. Thank you, Mariana, for the intro. I just switched on my slides. Hope you can see my screen. So again, thank you for Mariana, and thank you for the China IP Help Desk to support this event today. My name is Iman Wang. I'm coming from 36KR. Allow me to do a very short introduction on who we are, what we do. In very short, we are like the leading technology media in China, covering the startup and venture capital scene. 36KR, we are founded in 2010 already, like 15 years ago. We went public on Nasdaq in 2019. And today, we're basically the #1 technology portal in China. We have 30 million followers and around 800 million of monthly page views. So we're pretty much the master read for venture capitalists and startup founders and corporates who are interested in technology, in innovation in China on the kind of daily basis. We operate in different sectors and different geographical scopes. We have our sister sites in Southeast Asia, in Japan, and I'm responsible for KrEurope, which is the European edition of 36KR for our European readers. Let me show you shortly. This is our flagship site, 36kr.com. As mentioned, this is kind of the first website that all the Chinese venture capital investors will be reading in the morning every day. We're pretty proud of that. And of course, KrEurope, this is our dedicated platform, which is serving our European readers, launched in 2021, covering business and technology insights around China, hot topics, big tech moves, and startup news, etc., etc. Beyond that, we leverage also our media network and database to provide different kind of consulting services. So I'm just going through this very quickly. In a nutshell, we do 3 pillars of services. We do a lot of publicities, PRs, IRs, relationships, marketing for brands, unicorns, corporate, and sometimes also public stakeholders. We provide data and research services to large organizations, investors, and corporates. And we also act as advisors to corporations for venture capital funds in terms of innovation, startup consulting, startup management, and innovation management, etc., etc. So just some references what we have done in the past. For example, I still might aware of the Chinese e-way maker Neo has now arrived in Europe. We support Neo in Europe for a range of PR activities. We also helped Klarna to enter into the Chinese market, do the local PRs on the Chinese media in Chinese language. We supported corporates like Forward 31 from Porter to do local ecosystem events and connect with local startup founders and investors. We supported also corporates like Volkswagen to arrange festivals, style summit, focusing on technology challenge and innovations. And of course, a lot of online webinars like the webinar we're organizing today together with the China IP Desk. Also research and scouting, we conduct a large range of research and analysis for our clients. Today's topic is about AI, so allow me to post one shortly screenshot of one article we recently published on KrEurope on this topic, because it is a very hot issue nowadays, not only for startup founders, but also for investors, for corporate users, how to safely use AI and the technology in the technology trends now in China, and also to protect your own intellectual property right. So yeah, we are super happy to have today's discussion together with our legal expert who's very familiar with this issue. So I think I'm now moving the floor or the presentation to Liu Dan, our legal expert and the main speaker of today's event. So Dan, I'm giving back the microphone to you.
Thank you, Emil. And hello, everyone. My name is Dan, and today I'm very happy to be here, to be invited by Mariana and Emil to share my thoughts on these exciting topics. Now I'm going to share my screen, so just 1 minute. Okay. Now I think you can see my screen. If you have any problem, just type it in the chat room so we can solve it quickly. Okay. Now this is topic that is quite new, I have to say, because for the public that to get to know about AI and AI technology is since I think probably 2016, when there's a breaking news to say that AlphaGo has beaten one professional Go players in one place. And from that moment, the AI technology has been pushed in front of the spotlight of the world. And later, with the appearing of the ChatGPT, even to push these discussions to the next stage. And for the first time, I've seen that there's some kind of panic from among the human being society to say that, okay, then what is the next? What is the capability of the artificial intelligence? And what is the future? May AI dream of electric sheep, or maybe they will be the next master of the planet. So, and this is my profile. Before we go to today's topic, I would like to share with you first of a brief history of the artificial intelligence. So on the left of the screen, we can see it is from 1950s. There's a startup of the AI technology, and the first time appearing of artificial intelligence, this term is on one seminar organized in USA in 1956. And in that meeting, they said that the artificial intelligence is stimulate the human intelligence with machine. And later in the 1980s, now the traditional machine learning has step by step to tends to the deep learning. and appearing of the theory of CNN and back propagation in multi-layer perceptrons, and also later the deep blue that has appeared, has developed by the IBM, has made the AI technology from a purely theory to go to the application. And in the beginning of 2000, thanks to the development and the great achievements of the big data and computing powers development, we first to have the generative AI. And in 2014, here appearing the GAN, that is almost the basis of the AIGC. And after 2020 till nowadays, now the AIGC industry has boomed up. On the right of the side, I have gave some examples of the most popular AIGC applications that are open to the public in different fields, in the text, in video, to generate images and code or 3D models and others. So when we talk about artificial intelligence, what are we talking about? The European Parliament has gave a definition to say that AI is the ability of a machine to display human-like capabilities, such as researching, learning, planning, or creativity. And in the IBM, it also gave a similar definition to say that AI is technology that enables computers and machines to stimulate the human intelligence and problem-solving capabilities. So here comes with the question or the doubt that if AI can thinking like human intelligence, may it also commit crime like human intelligence? And if so, who will be the person or who will take the responsibility for this crime? Now I'm going to start with my presentation today, and here is my agenda. The first part is introduction of China's first IP infringement case involving generative AI service providers. This is our first case that happened at the beginning of this year, which has reached a widely discussion, both in the AIGC industry fields and also from the legal professionals. And the second part of my presentation will have a general view of the interim measures for the management of generative AI services. This is the first rule in China to governing the generative AI services. So I think it's quite interesting and will have a great influences to businesses that will use the AI technology. And at end of my agenda, I'd like to give some advices based on my experience in China on the using AI for businesses. Okay, this is the case that just happened at the beginning of this year. In February 8th of 2024, the Guangzhou Internet Court has published one judgment concerns the generative AI service provider infringing copyright. And here are two parties of the dispute. The plaintiff is Shanghai Xinchuanghua Couch Development Company, who is the exclusive licensing agent of the world-renowned characters such as Ultraman series. I think everyone knows these characters, and it's in China. In recent years, it's even more popular than before. And the defendant is one AI company that is operating one website. Here, they only give allies in the judgment, so we don't know the actual name of the website. But in the website, the defendant provides generative AI drawing services to its paid users. The users, after registered in this website and pay for certain fees, they can use this tool to generate the images with certain prompts. Here's the timeline of the dispute. At the end of 2023, the plaintiff has found that the AI drawing model offered by the defendant's website can generate images that are substantively similar to the protected Ultraman works of art. After that, the plaintiff decided to sue to the Guangzhou Internet Court for the copyright infringement, and specifically for the right of reproduction, right of adaptation, and right of communication through information networks. 1 month later, on the 4th of February, the court organized a hearing through the summary procedure. This procedure is a little bit different from normal procedures. When this will be chosen is when the judge believes the conflict of the case is not serious and the fact is clear. So the judge think there's no need to have a team to examine or train or dealing with this case. So that means this case, from the judge's point of view, is not a complicated one. 4 days later, after the hearing, the court issued the first instance judgment. Here in the petition, the plaintiff has claimed, first, the defendant to cease to continually generate infringing images, and second, to remove Ultraman materials from the contested training dataset, and third, to compensate the damages that suffered by the plaintiff, which is around 30,000 RMB. In responding to the plaintiff's petition, the defendant argued first that the first moment when they received the notice from the court and get aware of this dispute, they have taken measures to stop generating the alleged infringing images. And second, the contested AI drawing model was trained and offered by a third party instead of the defendant himself. Therefore, the defendant have no right to access to the AI training data set, not even mentioning to change or remove the materials from the data set. And third, the defendant argued that the contested images were generated by the user of the AI module. In this case, it's the plaintiff himself that has generated the images, infringed images, by typing the prompt by the plaintiff. And therefore, the defendant believes that as he himself did not conduct the infringing activity, he should not be the one that takes the responsibility. After viewing the facts of the dispute and also hearing the arguments both from the plaintiff and the defendant, the court summarized the key issues of this dispute as 2 questions. The first is whether the offering of generative AI models trained by third party through programmable interface may constitute infringement when the generated results are same or substantively similar to the protected works. And second, if the answer is yes, what are the liabilities borne by the infringer? Regarding the first question, the court took the traditional copyright infringement assessing principle in China, that is substantively similar plus possible to excite. So the first element is that the court will make a comparison of the works that under protection by the copyright law and with the alert infringed images to see if the infringed images have remained all the originalities of the protected works. If so, then there is a substantively similar between these 2 images. And the second element is about the possible to access. This means by evaluating the well-known of the plaintiff's work, as well as other facts, to see if the defendant has the possibility to access to this work before generated the infringed image. Here is a comparison with between the Ultraman image and the protection and the images that's generated by the contested AI drawing model. After comparison, the court confirms that the originality of the Ultraman and the protection is it's a silvery body with white, blue, and yellow lines across the body. As well, the face, there's a crystal just in front of the top of the face, as well as elliptical eye-shaped eyes. After comparison, the court confirmed that the three images on the first line of the right that generated by typing a prompt with Ultraman is same to the original work, and the rest of the 7 pictures here generated with other prompts that linked with Ultraman is actually an adaptation to the original work. Therefore, the court concludes that the alleged infringed AI-generated images are substantively similar to the Ultraman and the protection. And regarding about the possible access, the court has considered the well-known of Ultraman in China, as well as there's a great amount of pictures, TV series, and movies that have published in China. The court thinks there's a reasonable possibility that the defendant has access to this image before generated this generated these images by the AI drawing model. So with the above analysis, the court answers to the first question as yes, there existing copyright infringement by generating the images that substantively similar to the works that and the protection. Then we come to the second question, as we have confirmed there is a copyright infringement. Then who is the infringer? And what is the liabilities that shall borne by the infringer? The defendant argued that it should not be the infringer because, as it has argued at the beginning of beginning, as we have introduced that the AI model was trained and provided by third party. What the defendant has done is to use the programmable interface that's opened by the third party to connect to this AI model and to put it on their website for their users to generate images by using this AI model. So the defendant himself didn't train the model or develop the model. And second, the defendant saying that the contested images were generated by the user. I mean, in this case, it's the plaintiff himself. It's not the defendant who has tapped in the prompt of Ultraman or Ultraman attaching with other characters to generate the alleged infringed images. Therefore, the defendant is not the one who actually conducted the infringing activities. So with these two reasoning, the defendant argued that it was not the infringer. While the court has rejected the arguments of the defendant, it found that the defendant was a generative service provider in accordance with the interim measures for management of generative AI services. In its Article 22.2, it has gave a definition of the generative AI service provider. It refers to organizations and individuals that use generative AI technology to provide generative AI services, including providing generative AI services through the provision of programmable interfaces, etc. With this analysis and the conclusion, the court believes that the defendant shall fulfill the obligations imposed by the law on the generative AI service provider. Otherwise, it will or it shall take the responsibility. So after analysis of these two questions, the court in its judgment has give decisions on the defendant shall cease infringement. That means the defendant shall employ measures to stop generating infringing images, reach an effect that no images that substantively similar to Ultraman's works of art will be generated by the contested AI model through normal use of prompts related to Ultraman. And the second, to require the defendant to pay the compensation that's suffering by the plaintiff, but with a reduced a third of the originally claimed by the plaintiff, that is 10,000 RMB. The reason why it requires the defendant, or why the defendant shall take the responsible for compensation, is the defendant failed to exercise reasonable care and their existing negligence. But the court has rejected the claim of the plaintiff for removing the infringing material from the contested AI training dataset. On this point, the court has taken the defendant's argument to say that the defendant did not perform the AI model training by himself. In order to support the defendant's argument, it has provided the evidence of the agreement that the defendant signed between them and the third party, the one who has actually trained and provided the AI model, as well as the order sheet and the deputy notes between them. So here is the case, and the key messages from this decision, they are: first, there's the court has given a very broad interpretation on the generative AI service provider. This, on one hand, is because the court has thinking or in understanding the interim measures that on the Article 22, the definition of the generative AI service providers should include everyone or every player in the whole AI value chain that use or develop this AI model or use this AI model to provide service to the consumer users. So with this interpretation, I think there's only the consumer users can be accepted from this generative AI service providers. All the rest in the whole chain will be involved. And the second is the court has reconfirmed the two attributes of the generative AI that's given by the Beijing Internet Court. The case that Emon has just introduced in his presentation of the article, it was in 2023. The Beijing Internet Court has gave a judgment on the AI generative content copyright to give a decision on that. At current stage, the generative AI module or other generative AI or other AIGC tools, they are tools to to support human beings to perform their creativity. So in a simple word, they are machines, they are tools, they are like the Beijing Internet Court even gave an example to say that AI generative AI model is more like a camera that can be used by the public to generate or to create the image that they have imagined in their mind. The third key message that we have received from this decision is that it has inconsistent with the previous copyright infringement cases that negligence is the premise for compensation. So why the defendant is required to pay for the damages that suffered by the plaintiff is because he did not fulfill all the obligations imposed by the law, and this negligence from the defendant. But after reading this decision, I think there are still some issues that is not solved yet. The first, as I have just explained, seems, from my personal point of view, I think the court has interpreted of the generative AI service providers too broad. I mean, as we know, currently the AI GC industry has boomed up, but if we take a view of the whole industry, there's only very few giant companies that have the capability and the capability to develop their own large model. All the rest of a great number of operators, they are developing their businesses based on this large model. We can call them like middle layer or top layer in the AI value chain. The middle layers, for example, they are based on the pre-trained large models to develop in certain fields or strengthen or emphasize its function in certain fields. I will take an example of the Beijing Internet Court case in 2023 again. As in that case, the plaintiff is also a user of a generative AI service model, and that model was not directly developed by the user, but by a third party. But even the third party is not him or herself to develop the large model, but based on the stable diffusion large model, and then they have made some merges with other models to create a new application that can generate images with high quality, but also with the characters that meet the demands of the user. In that case, the user would like to generate some pictures that with the Asian face, like a young girl. Also, it was actually true, like a photo. So this model is trained to or modified to meet the specific demand of the specific group of user. And also there's also other top layers in the AI value chain. They are not like the defendant at our case. They are not directly to develop the large model. Even they are not the one to train the AI model or to offer the AI model. They are only to use the programmable interface that's opened by the third party, by the trainer of the AI service model, and then to offer to their end users. to generate or to use the AI model. As we know that currently in China, I mean, if you are located in China, there's many models or AI large models, even they are open to the public. We cannot access it from China, but many businesses, operators, they have found a way to link or to do the technical arrangement in order that the users or their users in China mainland can access to or to use the service of the large AI model. So if the court has give such a broad interpretation of generative AI service providers, I'm afraid many small and medium companies that will be locked outside of this market, and they are not able to generate their own or develop their own AI models. On the other hand, they have taken a very serious responsibility or very high responsibility of keep all the generative to keep the generated results legal and to keep the surveillance on it. I think that burden is too much, especially for small and medium entities. So on this point, I think the EU AI Act that is still under discussion, not enforced, can be a good example, because in that act, it has divided the players in the AI value chain into different rulers or roles. For example, the providers or the deployers, the importer and distributor, and then the user. And also it gives or set up the responsibility structure is risk-based approach. So they are not only to divide or classify the role in the AI value chain, but on the other hand, they also give to separate up the level of the risk. With each level of the risk, they give a specific or equally responsibility. So I think this will be more realistic and more reasonable. In this way, everyone knows that they will take a responsibility, of course, but also they will take the responsibility that equals to their benefits or to their expectations in this field. So I think that is more reasonable. And the second question is about the conflict. I think this court may conflict, this decision may conflict with the decision of the Beijing Internet Court, because in the 2023 case, the AI generative content copyright, the Beijing Internet Court has confirmed that the user who has typing prompts or designed prompts to generate images through the generative AI model is the owner of the generated out the result or the image. So, and the user can claim copyright or prevent others from infringing the copyright of the generated images. While in this case, in the case at hand, the court has required that the defendant who actually if as we have as the court has categorized as the defendant, the generative AI service provider who should take the responsible of infringing others by the generated images. So with a principle of no rights, no obligation, if we impose the responsibility or the defendant shall take the responsibility of infringing others by the generated images, then I think that the logical way to think is, if there's a copyright on the generated images, it should also be the defendant, that who is generative AI service provider who provided the AI model. But this will conflict with the decision of the Beijing Internet Court. And the third issue is, I think in the judgment, the court has to give a decision to force the defendant to employ measures to stop generating the alleged infringing images, to reach an effect of banning measures that by normal use of prompts. But here, there's no clear criteria on what is reasonable requirements on the effects of the banning measures. For example, during the hearing, the plaintiff has logged into the contested website to show to the court how this AI model working on that website. The defendant has argued that once they have noticed or they have been informed of this dispute, they have taken measures to stop the continually generating the alleged infringing images by using prompts such as Ultraman. So when the plaintiff to log in the website and to give a prompt of Ultraman, it's true that it's not appearing the images as they have tried first before the dispute. But later they have changed the prompt. They changed to the name of the Ultraman, and then the AI model has generated once again the image of Ultraman that is the same or substantively similar to the images that under protection. So the court thinks that the defendant has not taken enough measures that to stop this infringement. But how could we evaluate if the measures is effective or not? What if there's a third party or third user that's using a prompt that is so detailed, describes all the characters of the Ultraman without mentioning Ultraman or its name? There's still a possibility that it generated an image that's substantively similar to Ultraman. Then can we give a decision, can we saying that the defendant still not give enough measures or to reach the effect required by the court, or we should identify it as abnormal use of prompt? Here we still have doubt on this point. And the last, as mentioned and shown by the defendant, the AI model was actually trained and offered by a third party. So whether the defendant can request a disclosure or even intervention of the upstream generative AI model provider, because they are the one that who actually train the AI model and who actually can access or even to remove or input or control the data set of the AI model, as what the court has given decisions that say the defendant cannot access to the data set, so they reject the claims from the plaintiff of removing the Ultraman's materials from the AI module, from the AI module data set. So under this condition, whether the plaintiff or the defendant can request a compensation from this upstream third party or not. These are at least in this judgment, we cannot see whether the court has considering this point, or maybe because the defendant or the plaintiff didn't require for that. So we will see what's in future. Okay, then I'm quickly to go through the part 2 of the interim measures for management of generative AI services. So this, as I have been introduced, this is the first specific rule that in China we have published and enforced to regulate the generative AI services. This was issued by 7 ministries jointly. This was enforced on the 15th of August 2023. On this interim measures, as we have seen in the Article 22, is give a definition on the generative AI service provider and the generative AI service user. This rule has simply to divide the groups of the users in the AI value chain to provider and the user. As the court has given very broad interpretation on the service provider, the user will be only the group that the customer user that use the AI model to generate content for themselves or for any commercial purpose. Here are the obligations that bear by the service provider. Article 4 is a general principle required to comply with law. That is also needed to respect the social morality and ethics. This is an abstract principle rule. Article 7 is the lawful training. It requires the training data processing activities and optimize the training in accordance with law, and the source should be lawful. Also need to respect the IPR or respect the personal information. So from this article, maybe if, for example, the defendant in our case has request a disclose or even to claim damages from the third party who is actually the AI module trainer, maybe rely on this article, but we are not sure yet because in case the third party is in abroad or there's another third level who is the actual AI trainer, and even to go back to the basis layer that is the large model developer. I don't know that is possible, or maybe or at least it's not so easy. Article 9 is online information security and personal information security. That means that it requires the provider take the responsibilities of online information content producer, and also if there is a personal information involved, it will bear the responsibility of personal information processor. This is quite heavy from my point of view, because that means the generative AI service provider has to take responsibility of all the content that's generated by their AI module. And also, if there's personal information involved, it has to take all cares about the personal information, for example, to keep it safe, confidential, and not disclose to third party, not transfer to others without authorization, or remove or delete it from the data site if required by the right owner, etc. And Article 10 is a social responsibility. I have to say that this is some kind of China style, because they pose more social responsibilities to the entities, to the public bodies. Here is the rule that the provider shall guide users to scientifically and reasonably to understand and lawfully use generative AI technology, and to employ measures to prevent minor users from overly relying on or becoming addicted to the generative AI services. So maybe it is necessary to separate it up of your services into two groups at least, for One is for the general user, another is for minor users. Like TikTok has done in China, I think there's one version specifically focused on the minor users, and the contents are different. Article 11 is about information protection. So it requires the provider protect the information that's provided by the user, not collecting unnecessary personal information, not requesting that recording the identifiable personal information, etc. Article 12 is the labeling. It said that if for those who provide deep sensor services that may cause confusing or misidentification among the public, it shall use the method to label the AI statistic or the statistic information content. That is also one of the obligations that the court has opposed to the defendant in the case at hand. It says that if the content may cause misidentification of the resource of the image, the defendant shall make this kind of label. And Article 14 is about surveillance, warning, and reporting. It says that the provider has to post active surveillance on the content that's generated by their AI model, and needed to record and reporting to the authorized offices if necessary. Article 15 is requiring the service provider to establish a complaining mechanism to receive the complaints from the true or the genuine right owner in order to prevent the continually infringing of the third party's right. Article 17 is about to record to require that the providers who is offering generative AI services that having public obtaining attributes of social mobilization effects. This is a little bit complicated, but here I gave some examples. At the end of this page, you can see that it includes about launches of information services such as BBS, blog, macro blogs, chat group, and also with launches of channels for voicing public opinions or other internet information services having the capability of mobilize the public to engage in certain activities. So this is to keep or to maintain the safety of the public or safety of the society, not to raise any conflict between the public. Okay, now I go to the last part of my presentation. Here are some advices on using AI for businesses in China. Based on my experience and based on my introduction of the case that in the beginning of my presentation, I think there are something that you need to think about before you decided to come to China or before you decided to launch your AI module services to Chinese customers. First, you need to confirm your position in the AI value chain. That not only your position, but also your upstream providers or your downstream end users or other providers. And you need to carefully draft contracts that clarifying your rights and obligations of all parties, both with upstreams and downstreams. Like in the case at hand, the defendant shows the agreement, but we don't know the detailed content of that agreement. Normally, the AI model providers, they will give these terms to clarify that they have gave up any rights on the generated images, or they may claim the copyright or other rights on the generated results. So you need to prepare this document carefully. Third is to set up statement or warning in your AI module application to be sure that your user understands your AI module can only use for legal purpose. That means cannot to do something that is illegal. And if so, you may or you should report to the authorized offices or stop or take measures to stop service to the specific user. And the fourth is a proper label on the AI-generated content if it may cause a misidentification of the public. The fifth is to establish complaining mechanism and follow-up processing. So with this mechanism, you will be able to receive the right owner's complaints timely and to deal with it at the very beginning of this infringement. Next is activity surveillance and monitoring the generated content. So as it posted in the rule in the measures, it says that you have to also the AI service provider have to take responsibility of all the generated content that published online or through the other channels. So you better or you need to have this surveillance system in your application. Next is record and report to the authorized offices if you have detected any illegal activities or illegal content. Next is to watch out the red line. For example, the fundamental rights, the personal identifiable information or society, security or morality or ethics. So if you touch this red line, it's not only that you may receive a huge or serious punishment, it may be an end of your business in China because currently we are quite sensitive for these topics. And last and not least, you should always seek advices to your experts in this field, to listen to them and to see what is the best practice for you. Okay, this is the end of my presentation. As I have seen in this judgment and other documents and publications, now the whole country has recognized the AI is a strategic technology leading the future. So all the countries would like to incentive or to encourage the development of AI technology. But in the meanwhile, they also need to balance the right protection and also the AI industrial development. So they all take the attitude is to make the minimum control on the AI technology and to try to encourage the development of this technology. So thank you for your listening, and I gave my screen back to our hostess. Thank you for your time. Hi, Mariana.
Hi, thank you so much, Dan. I'll just go back here to my, oh. Can you see my screen? Okay, good. Thank you so much, Dan. That was very interesting, and I'm sure we all learned a lot from that. So from the audience, if you have any questions, if you want anything clarified, please take advantage of the fact that we have an IP expert right here, and any question that you might have, she can answer. If you want clarification on something she talked about, if you would like her to talk more about something, please write it down in the chat. And maybe I'll start by reading one question that we already have. And Dan, please take your time to answer it. So it's about the economic side. So how much would it cost for the plaintiff to initiate such case? For example, the Ultraman case for 30K Chinese yuan damage claim versus the 10K awarded. And how do we know how long it takes from the case opening until the court's final decision? Please, Dan, when you're ready.
Thank you. Thank you for your question. Actually, this this is a case that is quite fast compared with other cases similar to similar disputes. The copyright infringement normally they would take like 1 year or even longer to have the first judgment. But this one, as I have explained, it takes through the summary procedure. That means the court believes the fact is clear and there's no much dispute that is complicated. So that's why they only need one judge to organize one hearing and give a decision. If we see the timeline, the time that the plaintiff has raised this litigation is on 4th of January of this year, and then on 4th of February, the court has organized the hearing, and 4 days later, they gave the judgment. So it's super fast. And regarding the compensations here argued, the plaintiff has required or claimed for 30,000 RMB at the beginning for damages, but the plaintiff didn't give very detailed evidence on how they calculate this damages. It's just to say that based on the law that has ruined the damages for a copyright like us, like the Ultraman that is well known in China, we think it's reasonable to give 30,000 RMB, and it also includes the reasonable stance by the plaintiff. I see in the judgment that I didn't remember it very clear. It's around 10,000 for this reasonable cost. So for the damages of the images of the copyright, it should be around 20,000. But at the end, the court has only upheld a third of this compensation, because from the court's point of view, I think probably they also considered about the fact that the defendant has no capability to control the AI model or even not access to the data site. So he's only to offer this service to his user. But even for the plaintiff who has registered in that website and used the prompt to generate images of Aftermath, he didn't pay the fees because it thinks there's some discount or some policies from defendants. So the court should considering of this fact and has reduced the damage to be paid by the defendant. Yeah.
Okay, great. Thank you. We have another question here. So, are there current proceedings related to the topic of technical invention generated by AI, specifically inventions assisted by AI that have been patented, specifically utility patent?
Okay. Based on my memory, I think there's not recently, but before, yeah, I think we have a new recently to say that the CNIPA, the China National Intellectual Property Administration, who is managing the patent examination and granting, have refused a patent application that identified the AI as the inventor of that invention. It's that still we back to the basic principle to say that AI at least at the current stage is still a tool to support or to help human beings to perform or create something. The AI itself cannot be the inventor, because the inventor can only be the human beings, not machines, not even they are quite smart. Okay.
Yeah, okay, great. Yeah, I also have a question. And also from the audience, if you have any other questions, please feel free to write them. And also, if you come up with a question later on after the webinar is over, please feel free to email them to me or reach out to us through social media and we'll have them answered as well. But Dan, since AI seems to be progressing so fast, and I'm sure a lot of businesses rely on it to stay ahead of competition, and since the world of startups especially right now, is crazy. And there's, people are trying to get ahead in a bunch of different ways. Do you think that AI laws can ever really keep up? Because, with legal proceedings and everything relating to laws, it's very time consuming, and it seems, at least to me, that AI is always coming up with something new, and there's always something new coming out. So do you think, a time soon or not soon that AI laws will be less of a nuance and more of a concrete thing that people can really know exactly what they're doing, or will it always, you think, be something abstract?
Okay, I would like to read the line that I have cited. I don't know if you maybe no need to share my screen, but here is I like it very much. It's from the USA's hearing by the witness Ms. Garcia, the professor of the law school. He says that I consult legislative restraint that this advice stems predominantly from the fact that it is still early days for generative AI and copyright. So it's difficult to determine what sort of intervention, or if any, might be most helpful. So I think this is the common understanding for all the countries, or the major countries, that they think the AI technology is still in this very early stage. As you have said, that every day we have new applications that rely on AI models, and we don't know what is the limitation of the AI and what's the capability of the AI. That's the beautiful of this thing. That, I mean, this is where we can show that human imagination, how great of human imagination, that you can think there's a new thing. Everyone think about how to make the best use of it, and how to use it to create a new thing that to benefit the public, or to create another new thing. So I think it won't be so soon that we see that concrete or very solid AI act that's going to control everything. I think the country also needs to see, and also willing to wait for a while to see which is the direction of this technology goes. So that's it.
Great. Thank you so much for all your very detailed answers. And again, thank you so much for your presentation. And to everyone, feel free to connect with the China IP SME Help Desk on our social media. Like I said, if you have any other questions, feel free to reach out to us there, and we'll reach out to Dan so she can answer them. And also, don't forget to connect with KrEurope 36KR to be up to date with all the latest tech updates. Ima, do you have any last words you want to share before we finish?
Actually, I have one message. I don't know if we still have time for that. Someone sent me one question on the directed chat. I'm just reading it out loudly now. So the question is, as a foreign company, do we need to have the IP registered in the Chinese legal system in order to get protected? Does the IP protection terms differ from it in the EU, in the European Union? So maybe Dan could quickly feedback on this one.
Okay, I'm not very sure if I understand it correctly. We are talking about the IP protection in general in China. I think intellectual property law is kind of a modern law compared with civil law or criminal law. So China has shared a lot of common understanding with another countries. Especially, we have taken a lot of understandings from America, from the European Union. So it's always suggests that if you are coming to China, you need to check out what is your IP asset. You need to protect it before you come to China market. And I don't know if you have read some news just several years ago in China, it's so common that the foreign companies' trademark has been registered by some Chinese individuals without authorization, and it takes so much effort of the foreign companies, even big companies, to get that trademark back or have to change their strategy to in China market. They even need to change their trademark or other labels. So this is quite sad, but I think recent years it has improved a lot in China, but still we always advise our clients to have a list of all your assets and to know which part maybe you will deploy it in China, and to perform your IP protection in China before you actually come. And some of our clients, they even to register their trademarks years before they decided to come to China, because the second question of Eamon has mentioned about the term of IP protection. I think in general, the term of protection is same in European Union, but I think there's a little bit different for the industrial design. As I remember, the RCD in European Union is maximum for 25 years, but in China now we just modified the patent law, but still we are only give 15 years for protection. And also for copyright law, I don't remember exactly whether in European Union you give it for the whole life of the author and 50 years after they pass away, or 70 years. USA gave 70 years, but in China we gave 50 years after the pass away of the author. So maybe European also share the same. But for patents and trademarks, we are the same. Like for patents, invention patents and utility model is only for 10 years. For invention patent is 20 years, and for trademarks is 10 years. You can renew it every 10 years. That's it.
Thank you, Dan. I think that might mean that if we want to protect our IPs in China against the AI tools, the first thing is to patent, to register IP. Otherwise, we don't have much protection against like AI models, AI tools, right?
Yes.
Thank you.
Yeah, also we, like I mentioned in the beginning, we have a comprehensive guide on all of those, the steps that you should take before doing business in China in order to protect your IP. And as Dan said, the best thing to do is to make sure it's protected before you start doing business there. And any costs related to that, we have a list of everything and how long each one lasts and everything, how much you have to pay. So please feel free to access our website if you're interested in that. So if there are no other questions and there are no other remarks, I think we can finish here. So thank you so much for everyone for joining, and thank you so much for Iman for helping me organize this. And of course, thank you to Dan for giving us a very engaging, very interesting presentation on a topic that is very novel and very, very interesting. So yeah, thank you everyone, and I'll hopefully see you in another webinar.